Question 1. Stakeholder feedback indicates that buyers in Arizona are sometimes confused about the role of title companies and the necessity of title insurance. A real estate licensee is assisting a buyer with a purchase. What is the most appropriate action for the licensee to take regarding title insurance? Option A. Explain the general purpose of title insurance and the title company's role in clearing title. Inform the buyer they have the right to choose their title company and escrow agent, and answer any questions the buyer may have about the process. Option B. Recommend a specific title company that the licensee has worked with frequently, highlighting its efficiency and reliability. Option C. Advise the buyer that title insurance is generally not required and can be an unnecessary expense, suggesting they forego it to save money. Option D. Provide a detailed explanation of potential title defects and the legal ramifications of each, advising the buyer on which specific title insurance policy would offer the best coverage. Correct answer is A. Explain the general purpose of title insurance and the title company's role in clearing title. Inform the buyer they have the right to choose their title company and escrow agent, and answer any questions the buyer may have about the process. Explanation. This scenario is professionally challenging because it requires a real estate licensee to navigate potential conflicts of interest and ensure client protection while facilitating a real estate transaction. The licensee must understand the distinct roles of various parties involved, particularly the title company and its insurance products, and advise the client appropriately without overstepping their own professional boundaries or engaging in the unauthorized practice of law. Careful judgment is required to uphold ethical standards and comply with Arizona revised statutes governing real estate transactions. The best professional approach involves clearly explaining to the buyer the purpose and benefits of title insurance, the role of the title company in clearing title defects, and the fact that the buyer has the right to choose their own title company and escrow agent. The licensee should then facilitate the buyer's decision-making process by providing information and answering questions about title insurance, but ultimately deferring the final selection and decision to the buyer. This approach aligns with Arizona Revised Statute Section 32-2153, which prohibits licensees from engaging in the unauthorized practice of law and ethical principles that prioritize client autonomy and informed consent. It ensures the licensee acts as a facilitator and educator, not a decision-maker on legal or insurance matters. An incorrect approach would be to recommend a specific title company or title insurance policy based on personal preference or a referral fee, without fully disclosing any potential benefit to the licensee. This could violate Arizona Revised Statute Section 32-2155 regarding disclosure of compensation and could be construed as steering clients, which undermines fair housing and ethical practices. Another incorrect approach is to downplay the importance of title insurance or advise the buyer that it is unnecessary, as this fails to protect the buyer's interest in clear title and could lead to significant financial loss if title defects arise. This neglects the licensee's fiduciary duty to act in the best interest of the client. Furthermore, attempting to explain complex legal aspects of title defects or insurance coverage beyond a general overview could constitute the unauthorized practice of law, violating Arizona Revised Statute Section 32-2153. Professionals should employ a decision-making framework that prioritizes client education and empowerment. This involves understanding the scope of their own expertise and responsibilities, clearly communicating the roles of all parties involved in a transaction, and providing clients with the information necessary to make informed decisions. When dealing with specialized services like title insurance, the licensee's role is to explain the general purpose and options available, not to provide legal advice or make specific recommendations that could create a conflict of interest or exceed their licensing authority. Question 2. Risk assessment procedures indicate that an investor client in Arizona is interested in acquiring a distressed property quickly. The client has limited capital for a traditional down payment but possesses a strong credit history. The broker must advise on financing options. Which of the following represents the most professionally responsible approach for the Arizona licensed broker? Option A. Fully explain the characteristics, risks, and benefits of both hard money loans and seller financing, encouraging the client to consult with legal and financial professionals to make an informed decision. Option B. Emphasize the speed of closing associated with both hard money loans and seller financing, without delving into the specific costs and risks of each. Option C. Recommend hard money loans as the most suitable option due to the property's distressed nature and the need for quick acquisition, without extensively detailing seller financing. Option D. Advise the client that seller financing is the only viable option given the limited capital for a down payment, focusing on the potential for flexible terms. Correct answer is A. Fully explain the characteristics, risks, and benefits of both hard money loans and seller financing, encouraging the client to consult with legal and financial professionals to make an informed decision. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate broker in Arizona to advise an investor client on financing options for a distressed property. The broker must navigate the complexities of both hard money loans and seller financing, understanding their respective risks and benefits, and ensuring the client's best interests are prioritized while adhering to Arizona's real estate regulations. The urgency often associated with distressed property acquisitions adds pressure, demanding a swift yet thorough evaluation of financing structures. Correct approach analysis. The best professional practice involves thoroughly explaining the distinct characteristics, risks, and benefits of both hard money loans and seller financing to the investor client. This includes detailing the typical interest rates, loan terms, collateral requirements, and repayment structures of hard money loans, as well as the potential for more flexible terms, but also the risks of default and the importance of a legally sound agreement in seller financing. The broker must empower the client to make an informed decision by providing objective information and encouraging consultation with legal and financial professionals. This approach aligns with Arizona revised statutes, particularly those governing the broker's fiduciary duty to act in the client's best interest, provide competent advice, and disclose all material facts. It upholds ethical standards by ensuring transparency and client autonomy. Incorrect approach is analysis. Recommending only hard money loans without a comprehensive discussion of seller financing fails to provide the client with a complete picture of available options, potentially leading to a suboptimal or overly expensive financing solution. This neglects the broker's duty to explore all reasonable avenues for the client's benefit and could be seen as steering the client towards a product that may offer the broker higher commissions or faster closing, rather than what is truly best for the investor. Suggesting seller financing as the only viable option without a thorough assessment of the property's market value, the seller's willingness and capacity to offer financing, and the potential legal complexities of drafting such an agreement is also professionally unsound. This approach might overlook the benefits of a hard money loan, such as faster funding or less negotiation with the seller, and could expose the client to significant legal and financial risks if the seller financing agreement is not properly structured and documented according to Arizona law. Focusing solely on the speed of closing, without adequately explaining the associated costs and risks of either financing method, is a critical failure. Both hard money loans and seller financing have unique risk profiles that must be clearly communicated. A broker's primary responsibility is to the client's financial well-being and informed consent, not merely to expedite a transaction. Professional reasoning. Professionals should approach such situations by first understanding the client's financial situation, investment goals, and risk tolerance. Then, they should conduct a comparative analysis of all relevant financing options, including their regulatory implications under Arizona law. This involves educating the client about the pros and cons of each, encouraging independent professional advice, legal and financial, and documenting all discussions and recommendations. The ultimate decision rests with the informed client, with the broker acting as a trusted advisor facilitating that informed decision. Question 3. Operational review demonstrates that a real estate broker in Arizona has affiliated salesperson whose licenses are due for renewal in 6 months. The broker wants to ensure all affiliated agents are compliant with Arizona's continuing education requirements prior to their renewal date. What is the most effective and compliant course of action for the broker to take? Option A. Rely on each salesperson to independently manage and report their continuing education compliance without any broker verification. Option B. Wait until the license renewal deadline approaches, then ask each salesperson if they have completed their continuing education hours. Option C. Proactively verify the continuing education status of all affiliated salespersons at the beginning of the license renewal period and address any identified deficiencies immediately. Option D. Only address continuing education concerns if a salesperson brings a problem to the broker's attention or if the Arizona Department of Real Estate initiates an inquiry. Correct answer is C. Proactively verify the continuing education status of all affiliated salespersons at the beginning of the license renewal period and address any identified deficiencies immediately. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate broker to navigate the complexities of Arizona's licensing and continuing education requirements for their salespersons. The broker has a responsibility to ensure their agents are compliant, and a failure to do so can have significant consequences for both the agents and the brokerage. The challenge lies in identifying and rectifying potential noncompliance proactively and ethically, rather than reactively. Correct approach analysis. The best professional practice involves the broker proactively verifying the continuing education status of all their affiliated salespersons at the beginning of the license renewal period. This approach ensures that any deficiencies are identified well in advance of the deadline, allowing ample time for the salespersons to complete their required hours. This aligns with the Arizona Department of Real Estate's mandate that brokers are responsible for the acts of their salespersons and for ensuring their compliance with licensing laws, including continuing education. By taking this proactive step, the broker fulfills their supervisory duty and prevents potential license suspension or revocation for their agents, thereby protecting the brokerage reputation and operational continuity. Incorrect approaches analysis. One incorrect approach involves waiting until the license renewal deadline has passed to inquire about continuing education. This is a reactive measure that leaves little to no room for salespersons to complete any outstanding hours. It demonstrates a lack of diligence and oversight on the broker's part, potentially leading to agents operating with expired licenses, which is a direct violation of Arizona real estate law and carries severe penalties. Another incorrect approach is to assume that salespersons are independently managing their continuing education without any verification from the broker. While salespersons have a personal responsibility for their CE, the broker's statutory duty to supervise necessitates a level of assurance. This assumption can lead to unintentional noncompliance, as agents may misunderstand requirements, forget deadlines, or face unforeseen circumstances preventing them from completing their hours. This abdication of supervisory responsibility is a regulatory failure. A further incorrect approach is to only address continuing education issues when an agent brings it to the broker's attention or when a problem arises. This passive stance fails to meet the broker's affirmative obligation to ensure compliance. It suggests a reactive rather than a preventative management style, which is insufficient for maintaining a compliant brokerage operation under Arizona's regulatory framework. Professional reasoning. Professionals should adopt a proactive and systematic approach to managing licensing and continuing education requirements. This involves establishing clear internal policies and procedures for tracking agent compliance, conducting regular audits, and providing resources or reminders to agents. When potential issues are identified, the professional should engage in direct communication with the affected individuals, clearly outlining the requirements, consequences of noncompliance, and offering support to rectify the situation within the regulatory timeframe. This demonstrates ethical responsibility and adherence to legal obligations. Question 4. Compliance review shows that an Arizona licensed real estate broker is representing a seller in the sale of their property. The broker learns that their sibling is interested in purchasing the property and has expressed a willingness to pay the asking price. The broker intends to represent their sibling as the buyer's agent in this transaction and receive a commission from the buyer. What is the broker's immediate and most appropriate course of action according to Arizona real estate law? Option A. Inform the seller verbally about the familial relationship and their intent to represent the buyer. Option B. Immediately disclose in writing to the seller and their designated broker the broker's familial relationship with the potential buyer and the broker's intent to receive compensation from the buyer. Option C. Arrange for another agent within their brokerage to represent the buyer to avoid any appearance of impropriety. Option D. Proceed with the transaction, assuming the familial relationship is not a material fact that would impact the seller's decision. The correct answer is B. Immediately disclose in writing to the seller and their designated broker the broker's familial relationship with the potential buyer and the broker's intent to receive compensation from the buyer. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a broker's duty to their client and the potential for personal gain through a transaction involving a related party. Navigating this requires strict adherence to Arizona's real estate law, specifically regarding disclosure and fiduciary duties, to maintain client trust and legal compliance. The broker must prioritize the client's best interests while ensuring transparency about their own involvement. Correct approach analysis. The best professional practice involves immediately disclosing the broker's familial relationship to the potential buyer to the seller and their designated broker. This disclosure must be in writing and clearly state the nature of the relationship and the broker's intent to receive compensation from the buyer. Arizona Revised Statutes, ARS. Section 32-2155 mandates that licensees disclose any material facts, and a familial relationship that could influence a transaction is considered material. Furthermore, ARS. Section 32-2153 outlines the fiduciary duties owed to a client, which include loyalty and acting in the client's best interest, necessitating full transparency in such situations. This proactive disclosure ensures that the seller is fully informed and can make an informed decision, thereby upholding the broker's ethical obligations and legal requirements. Incorrect approach is analysis. One incorrect approach is to proceed with the transaction without any disclosure, assuming the familial relationship is not relevant to the seller. This violates ARS Section 32-2155 by failing to disclose a material fact that could affect the seller's decision-making. It also breaches the fiduciary duty of loyalty and full disclosure owed to the seller, potentially leading to a conflict of interest and legal repercussions. Another incorrect approach is to only verbally inform the seller about the relationship. While better than no disclosure, Arizona law generally requires material disclosures to be in writing to provide clear and verifiable evidence. Verbal disclosures can be easily disputed and do not offer the same level of protection or transparency as a written document, failing to meet the standard of clear and demonstrable compliance. A third incorrect approach is to have another agent in the brokerage handle the transaction to avoid direct disclosure. While this might seem like a way to circumvent the issue, the broker still has a supervisory responsibility over their agents and a fiduciary duty to their client. If the broker stands to benefit from the transaction, e.g., through referral fees or shared commission structures not fully disclosed, this indirect involvement can still create an ethical conflict and potential violation of disclosure requirements if the seller is not fully aware of the broker's indirect interest. Professional reasoning. Professionals should always err on the side of overdisclosure when dealing with potential conflicts of interest or material facts. The decision-making process should begin with identifying any personal or familial relationships that could reasonably influence a transaction. Following this, the professional must consult the relevant statutes and ethical guidelines of the Arizona Department of Real Estate. The paramount principle is to ensure the client is fully informed and their interests are protected, even if it means potentially complicating or delaying a transaction. Transparency, documented in writing, is the cornerstone of ethical real estate practice in Arizona. Question 5. During the evaluation of a residential property in Phoenix, Arizona, for a potential listing, a real estate licensee discovers evidence of an unrecorded easement that grants a neighbor access across a portion of the property. The seller is unaware of this easement and is eager to proceed with the sale at the agreed-upon price. What is the most professional and legally compliant course of action for the licensee? Option A. Proceed with marketing the property and completing the sale, assuming the unrecorded easement will not be a significant issue for the buyer. Option B. Advise the seller to ignore the unrecorded easement and not disclose it to the buyer, hoping it will not be discovered. Option C. Immediately inform the seller about the unrecorded easement and its potential implications, advising them to consult with legal counsel regarding disclosure and resolution options. Option D. Inform the seller that an unrecorded easement is not legally binding and therefore does not need to be disclosed to the buyer. The correct answer is C. Immediately inform the seller about the unrecorded easement and its potential implications, advising them to consult with legal counsel regarding disclosure and resolution options. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a potential conflict between a seller's desire to convey property and a buyer's right to clear title, complicated by an unrecorded easement. A real estate licensee in Arizona must navigate these complexities while upholding their fiduciary duties to their client and adhering to Arizona revised statutes, ARS, and ethical standards. Failure to properly address such issues can lead to legal disputes, financial losses for clients, and disciplinary action against the licensee. Correct approach analysis. The best professional approach involves immediately informing the seller of the unrecorded easement and its potential impact on the property's marketability and the buyer's rights. This proactive communication allows the seller to make an informed decision about how to proceed, which might include disclosing the easement to the buyer, attempting to obtain a release or subordination of the easement, or renegotiating the sale terms. This aligns with ARS, Section 32-2154, A1, which requires licensees to promptly deliver to all parties any documents relevant to a transaction, and ARS, Section 32-2154, A3, which mandates licensees to disclose to a buyer or seller any facts known to the licensee that would materially affect the value or desirability of the property. Ethically, this demonstrates honesty, integrity, and a commitment to client best interests. Incorrect approaches analysis. One incorrect approach is to proceed with the sale without disclosing the unrecorded easement to the buyer, assuming it will not be an issue. This violates ARS, Section 32-2154, A3, by failing to disclose a material fact that affects the property's value and desirability. It also breaches the duty of good faith and fair dealing owed to the buyer. Another incorrect approach is to advise the seller to simply ignore the easement and hope the buyer does not discover it. This is unethical and potentially illegal, as it encourages deception and misrepresentation. It also exposes both the seller and the licensee to significant legal liability if the easement is later enforced. A third incorrect approach is to tell the seller that the unrecorded easement is not legally binding and therefore can be disregarded. While unrecorded easements may have limitations regarding their enforceability against subsequent bona fide purchasers without notice, their existence is a material fact that must be disclosed. The legal status and enforceability of an easement are complex matters that should be determined by legal counsel, not a real estate licensee. Failing to disclose it is a violation of disclosure duties. Professional reasoning. Professionals should adopt a framework of proactive disclosure and client education. When a potential encumbrance like an unrecorded easement is discovered, the immediate priority is to inform the seller of its existence and potential implications. This empowers the seller to make informed decisions. The licensee's role is to facilitate the transaction while ensuring all material facts are transparently communicated to all parties, thereby protecting their clients and upholding professional standards. If legal interpretation is required, the licensee should advise the client to seek legal counsel. Question 6. What factors determine the permissible uses and development potential of a property in Phoenix, Arizona, and how should a real estate licensee ensure their client is fully informed about these aspects? Option A. The seller's verbal assurances regarding the property's zoning status and any perceived restrictions. Option B. The property's current use as demonstrated by existing structures and activities, which generally indicates compliance with all zoning regulations. Option C. The licensee's personal opinion on whether the zoning regulations are overly burdensome for the buyer's intended use. Option D. The property's current zoning classification, any applicable overlay districts, and the city's general plan for future land use, all of which the licensee must research and disclose to the buyer. Correct answer is D. The property's current zoning classification, any applicable overlay districts, and the city's general plan for future land use, all of which the licensee must research and disclose to the buyer. Explanation. This scenario is professionally challenging because a real estate licensee must navigate the complexities of Arizona's zoning laws and land use regulations while representing a client's interests. The licensee's duty is to provide accurate information and ensure compliance, which requires a thorough understanding of local ordinances and their implications for property value and usability. Misinterpreting or failing to disclose relevant zoning information can lead to significant legal and financial repercussions for both the client and the licensee. The best approach involves proactively identifying and communicating all relevant zoning restrictions and potential land use limitations to the buyer. This includes researching the property's current zoning classification, understanding any overlay districts, and investigating potential future land use plans or restrictions that might impact the property. By providing this comprehensive information, the licensee empowers the buyer to make an informed decision and fulfills their fiduciary duty to act in the client's best interest, adhering to Arizona revised statutes concerning disclosure and professional conduct. An incorrect approach would be to assume that the property's current use automatically implies compliance with all zoning regulations. This overlooks the possibility of non-conforming uses, which may be subject to specific limitations or eventual termination. Failing to investigate the zoning status thoroughly and disclose it to the buyer violates the licensee's duty of care and could lead to the buyer purchasing a property with undisclosed legal encumbrances. Another incorrect approach is to rely solely on the seller's verbal assurances regarding zoning compliance. While sellers may have good intentions, their understanding of zoning laws might be incomplete or inaccurate. A licensee has an independent obligation to verify such information through official channels, as verbal assurances do not constitute a legal guarantee and can lead to misrepresentation claims if proven false. Finally, advising the buyer to ignore zoning regulations because they seem overly restrictive is a professionally unacceptable approach. A licensee must uphold the law and advise clients on how to comply with it. Encouraging noncompliance or suggesting ways to circumvent zoning ordinances exposes both the client and the licensee to legal penalties and ethical violations. Professionals should employ a systematic approach. First, identify the client's objectives. Second, research all applicable Arizona zoning laws and local ordinances relevant to the property. Third, communicate all findings clearly and comprehensively to the client. And fourth, advise the client on potential implications and legal avenues for addressing any concerns, always within the bounds of the law. Question 7. Cost-benefit analysis shows that adhering to fair housing regulations can sometimes be perceived as an inconvenience by property owners. In Arizona, if a property owner instructs a real estate broker to only rent their property to individuals without children, what is the most legally sound and ethically responsible course of action for the broker? Option A. Advise the prospective tenant that they might find more suitable options elsewhere, without disclosing the owner's specific discriminatory reason. Option B. Agree to the property owner's request and only show the property to prospective tenants who do not have children. Option C. Politely but firmly inform the property owner that their request to exclude tenants based on familial status is illegal under the Arizona Fair Housing Act and federal law, and explain that all prospective tenants must be evaluated based on objective, non-discriminatory criteria. Option D. Decline to show the property to the prospective tenant, citing the owner's preference without explicitly mentioning the discriminatory nature of the request. The correct answer is C. Politely but firmly inform the property owner that their request to exclude tenants based on familial status is illegal under the Arizona Fair Housing Act and federal law, and explain that all prospective tenants must be evaluated based on objective, non-discriminatory criteria. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker to navigate a sensitive situation involving a potential tenant's protected characteristic, while also upholding the property owner's rights and adhering to fair housing laws. The broker must balance the need to avoid discriminatory practices with the owner's stated preferences, which could inadvertently lead to a violation of the Arizona Fair Housing Act. Careful judgment is required to ensure all parties are treated fairly and legally. Correct approach analysis. The best professional practice involves politely but firmly informing the property owner that their request to exclude tenants based on their familial status is illegal under the Arizona Fair Housing Act and federal law. The broker should explain that all prospective tenants must be evaluated based on objective criteria such as creditworthiness, rental history, and ability to pay rent, and that familial status cannot be a basis for refusal. This approach directly addresses the owner's discriminatory request by educating them on their legal obligations and steering the conversation towards lawful tenant selection criteria. This aligns with the broker's ethical duty to uphold fair housing laws and avoid facilitating illegal discrimination. Incorrect approaches analysis. Refusing to show the property to the prospective tenant because of the owner's stated preference would be a direct violation of the Arizona Fair Housing Act. The broker would be acting as an agent of discrimination, making them liable along with the property owner. This approach fails to educate the owner about their legal responsibilities and instead perpetuates illegal practices, suggesting to the prospective tenant that they might have better luck elsewhere without explicitly stating the owner's discriminatory reason would be a form of steering. While not as overt as outright refusal, it still indirectly discriminates by discouraging a protected class from pursuing housing opportunities, which is prohibited under fair housing laws. This approach avoids confronting the owner's illegal request and instead attempts to manage the situation by misdirecting the applicant. Agreeing to the owner's request and only showing the property to tenants without children would constitute direct discrimination based on familial status, a protected class under the Arizona Fair Housing Act. This approach demonstrates a complete disregard for legal and ethical obligations, exposing both the broker and the owner to significant legal penalties and reputational damage. Professional reasoning. Professionals in this situation should always prioritize legal compliance and ethical conduct. The decision-making process should involve 1. Identifying the protected characteristic and the potential for discrimination. 2. Recalling and applying relevant fair housing laws, Arizona Fair Housing Act and Federal Fair Housing Act. 3. Communicating clearly and professionally with the property owner about their legal obligations and the illegality of their request. 4. Offering to proceed with the rental process based on lawful, non-discriminatory criteria. 5. Documenting all communications and decisions made. Question 8. Stakeholder feedback indicates a seller in Arizona is eager to accept a buyer's verbal offer, believing the buyer's enthusiastic yes constitutes a binding agreement. The seller wants to proceed with the sale based on this oral commitment, with the intention of formalizing the agreement in writing later. As a licensed real estate broker in Arizona, what is the most appropriate professional advice to provide the seller regarding the enforceability of this verbal agreement? Option A. Inform the seller that an oral agreement is sufficient because the buyer has verbally agreed to the terms, and the broker can simply make it official later by drafting a written contract. Option B. Advise the seller that a written agreement, signed by both the buyer and seller, is necessary for the contract to be enforceable under Arizona law. Option C. Recommend that the seller proceed without a written contract, relying solely on the buyer's verbal commitment, as it demonstrates a clear intent to buy. Option D. Explain that while a written contract is ideal, the verbal agreement can be considered a preliminary understanding that might hold some weight if disputes arise, especially if there are witnesses. The correct answer is B. Advise the seller that a written agreement, signed by both the buyer and seller, is necessary for the contract to be enforceable under Arizona law. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a potential conflict between a seller's desire to expedite a sale and the broker's fiduciary duty to ensure all essential elements of a legally binding contract are present and understood by all parties. Misrepresenting the enforceability of a contract or failing to disclose material facts can lead to significant legal repercussions, ethical breaches, and damage to the broker's reputation and the Arizona Department of Real Estate's trust. Careful judgment is required to balance the client's immediate wishes with the long-term legal and ethical obligations. Correct approach analysis. The best professional practice is to advise the seller that a written agreement, signed by both the buyer and seller, is necessary for the contract to be enforceable under Arizona law. This approach directly addresses the core requirement for contract enforceability in real estate transactions within Arizona. Arizona Revised Statutes, A.R.S. Section 33-401 mandates that a conveyance of an interest in real property must be in writing and signed by the party to be charged. Therefore, an oral agreement, while potentially indicative of intent, lacks the legal standing to be enforced in a court of law for real estate transactions in Arizona. This aligns with the ethical duty of a real estate professional to ensure clients understand the legal requirements for valid contracts. Incorrect approaches analysis. Advising the seller that an oral agreement is sufficient because the buyer has verbally agreed to the terms is a significant regulatory and ethical failure. It misrepresents the law of contracts in Arizona concerning real property, which requires a written instrument. This could lead the seller to believe they have a binding agreement when, in fact, they do not, potentially exposing them to financial loss and legal disputes. Furthermore, suggesting that the broker can simply make it official later by drafting a written contract after the fact bypasses the fundamental requirement that the agreement must exist in writing at the time of formation to be enforceable. This is a violation of the principle that contracts for the sale of real estate must be in writing to be valid and enforceable in Arizona. Recommending that the seller proceed without a written contract, relying solely on the buyer's verbal commitment, ignores the statute of frauds as applied to real estate in Arizona, which necessitates a written agreement for enforceability. This approach is ethically unsound and legally risky, as it fails to protect the seller's interests by not ensuring a legally binding contract is in place. Professional reasoning. Professionals should always prioritize adherence to the law and ethical standards. When faced with a situation where a client's wishes might conflict with legal requirements, the professional's duty is to educate the client about those requirements and advise them on the legally sound and ethically appropriate course of action. This involves understanding the specific statutes governing real estate transactions in Arizona, such as the statute of frauds, and ensuring all contracts are properly documented in writing and signed by all parties to be enforceable. The decision-making process should involve 1. Identifying the legal requirements for contract enforceability in Arizona real estate. 2. Assessing the client's request against these legal requirements. 3. Clearly communicating the legal implications to the client. 4. Recommending actions that ensure legal compliance and protect the client's interests. Question 9. Stakeholder feedback indicates that a seller in Arizona is hesitant to disclose potential environmental concerns on their property due to fear of jeopardizing the sale. As a licensed real estate broker in Arizona, what is the most appropriate course of action to ensure compliance with Arizona law and ethical practice? Option A. Encourage the seller to avoid mentioning any potential environmental concerns unless a buyer specifically inquires about them, to prevent scaring off potential buyers. Option B. Conduct a brief visual inspection of the property yourself and make a determination on whether the environmental concerns are significant enough to warrant disclosure. Option C. Advise the seller to obtain a professional environmental assessment to identify and quantify any potential issues, and then facilitate the disclosure of these findings to prospective buyers. Option D. Advise the seller to simply state no known environmental issues on the disclosure forms, as long as they haven't personally witnessed any overt signs of contamination. The correct answer is C. Advise the seller to obtain a professional environmental assessment to identify and quantify any potential issues, and then facilitate the disclosure of these findings to prospective buyers. Explanation. This scenario is professionally challenging because it requires a real estate broker in Arizona to balance their fiduciary duty to their client with the legal and ethical obligations related to environmental disclosures. The broker must navigate potential liabilities for both themselves and their client, while ensuring transparency and compliance with Arizona revised statutes, ARS, and any applicable federal environmental laws that Arizona enforces. The complexity arises from the potential for undisclosed environmental hazards to significantly impact property value and buyer decisions, leading to legal disputes. The best approach involves proactively identifying potential environmental concerns and facilitating disclosure to all parties. This means the broker should advise the seller to obtain a Phase I environmental site assessment (ESSA) or similar professional evaluation if there are any indications of potential contamination, such as proximity to industrial sites, historical land use, or visible signs of environmental distress. This aligns with ARS Section 33-422, which mandates disclosure of known material defects, and the general ethical duty of a real estate professional to act with honesty and integrity. By recommending a professional assessment, the broker is enabling informed decision-making by both seller and potential buyers, thereby mitigating future liability and fulfilling their disclosure obligations under Arizona law. An incorrect approach would be to downplay or ignore the seller's concerns about potential environmental issues, advising them to simply not mention it unless directly asked. This fails to meet the disclosure requirements under ARS Section 33-422, which requires disclosure of known material defects, and could expose both the seller and the broker to significant legal repercussions, including lawsuits for misrepresentation or failure to disclose. Ethically, this is a breach of trust and professional conduct. Another incorrect approach would be for the broker to conduct their own informal assessment of the property's environmental condition. Real estate brokers are not qualified environmental professionals, and relying on their own limited judgment could lead to inaccurate conclusions. This could result in either overstating or understating the environmental risks, both of which are problematic. Failing to disclose a known issue due to an incorrect informal assessment is a violation of disclosure laws, while unnecessarily alarming potential buyers with unfounded concerns could jeopardize the sale. Finally, advising the seller to simply state no known environmental issues without any professional verification, especially when there are red flags, is also an unacceptable approach. This is a passive form of misrepresentation. If a reasonable person would have investigated further given the circumstances, and the broker failed to advise such an investigation, they could be held liable for failing to ensure a complete and accurate disclosure of material facts as required by Arizona real estate regulations and ethical standards. Professionals should adopt a proactive and diligent approach. When faced with potential environmental concerns, they must first identify the red flags. Then, they should advise their client on the necessity of professional environmental assessments. The broker's role is to facilitate informed transactions by ensuring all material information, including potential environmental hazards, is disclosed in accordance with Arizona law and ethical guidelines, thereby protecting all parties involved. Question 10. Stakeholder feedback indicates a need for clarity on prorating rent and handling security deposits in Arizona. A residential property in Phoenix, Arizona, is being sold with a closing date of October 18th. The lease agreement for the property, signed by the current tenant, requires rent to be paid on the first of each month in advance for that month. The monthly rent is $1,800, and the tenant paid a security deposit of $1,800 at the beginning of the lease term. The seller has collected the October rent from the tenant. What is the correct prorated rent amount the seller owes the buyer, and how should the security deposit be handled at closing? Option A. The seller owes the buyer $771.43 in prorated rent, and the full $1,800 security deposit is transferred to the buyer. Option B. The seller owes the buyer $1,028.57 in prorated rent, and the security deposit is prorated based on the closing date, with the buyer receiving $967.74. Option C. The seller owes the buyer $1,028.57 in prorated rent, and the full $1,800 security deposit is transferred to the buyer. Option D. The seller owes the buyer $771.43 in prorated rent, and the security deposit is prorated based on the closing date, with the buyer receiving $967.74. The correct answer is A. The seller owes the buyer $771.43 in prorated rent, and the full $1,800 security deposit is transferred to the buyer. Explanation. Scenario analysis. This scenario presents a common challenge for Arizona real estate brokers involving the calculation of prorated rent and security deposits in a mid-lease assignment. The professional challenge lies in accurately applying Arizona Revised Statutes, ARS, and established real estate practices to ensure both the buyer and seller are treated fairly, and that all funds are accounted for correctly according to the lease agreement and state law. Miscalculations can lead to financial disputes, potential legal action, and damage to the broker's reputation. Correct approach analysis. The best approach involves a precise calculation of the prorated rent and the transfer of the security deposit as stipulated by Arizona law and the terms of the existing lease. This requires understanding that rent is typically paid in advance and that the security deposit is held by the landlord for the duration of the lease, to be transferred to the new owner upon sale. The calculation for prorated rent should reflect the number of days the seller has occupied the property in the month of closing, and the number of days the buyer will be responsible for rent from the closing date onwards. The security deposit, being a prepaid sum for the entire lease term, should be transferred in full from the seller to the buyer at closing, with the buyer then assuming the landlord's responsibilities regarding its return at the end of the lease. Incorrect approaches analysis. One incorrect approach would be to simply divide the monthly rent by 30 days and prorate based on the closing date, without considering the specific terms of the lease regarding rent payment in advance, or the exact day the seller's responsibility ends and the buyer's begins. This fails to account for the actual rent payment schedule and could lead to either the seller paying for days they no longer own the property or the buyer not receiving rent for days they are responsible for the property. Another incorrect approach would be to prorate the security deposit based on the closing date. Security deposit is a lump sum held for the entire lease term and is not typically prorated in this manner. It represents a commitment for the full lease period and should be transferred entirely to the new owner who assumes the landlord's obligations. A third incorrect approach would be to assume the seller is entitled to a refund of the security deposit at closing and for the buyer to collect a new, separate security deposit from the tenant. This is incorrect because the security deposit is tied to the lease agreement and the tenant's performance, not the ownership of the property. The buyer steps into the shoes of the seller as the landlord and inherits the existing security deposit. Professional reasoning. Professionals should always refer to the specific terms of the lease agreement and relevant Arizona revised statutes concerning landlord-tenant relationships and real estate transactions. When dealing with prorations, it is crucial to determine the exact date of closing and the established rent payment schedule, e.g., paid on the first of the month for that month. For security deposits, the principle is that the deposit follows the lease obligation. A clear and accurate settlement statement, such as an Arizona Association of Realtors registered purchase contract, should meticulously detail these prorations and fund transfers to avoid ambiguity and disputes. In cases of doubt, consulting with legal counsel or a title company experienced in Arizona real estate law is advisable. Question 11. The risk matrix shows a rapidly appreciating real estate market in Phoenix, Arizona, with indicators suggesting potential overvaluation and a looming economic slowdown. A client is eager to purchase a property, expressing concern about missing out on potential gains. As a licensed real estate broker in Arizona, what is the most appropriate course of action? Option A. Advise the client to wait for a significant market downturn before purchasing, based on the broker's personal economic forecast. Option B. Downplay the economic indicators and focus solely on the recent rapid appreciation, suggesting that the current trend is sustainable indefinitely. Option C. Assure the client that the market will continue to appreciate at its current rate, encouraging them to proceed with a purchase based on this guarantee. Option D. Present the client with objective market data, including recent sales comparables, current inventory levels, and recognized economic indicators that suggest a potential shift in the market, while explaining the implications without making definitive predictions. The correct answer is D. Present the client with objective market data, including recent sales comparables, current inventory levels, and recognized economic indicators that suggest a potential shift in the market, while explaining the implications without making definitive predictions. Explanation. The risk matrix shows a rapidly appreciating real estate market in Phoenix, Arizona, with indicators suggesting potential overvaluation and a looming economic slowdown. This scenario is professionally challenging because it requires a real estate broker to balance their fiduciary duty to their client with the economic realities and potential risks of the market. A broker must provide informed advice without making guarantees or predictions that could be misconstrued as financial advice, which falls outside the scope of a real estate license. Careful judgment is required to navigate the client's expectations against the objective market data. The best approach involves presenting the client with objective market data, including recent sales comparables, current inventory levels, and recognized economic indicators that suggest a potential shift in the market. This approach educates the client about the prevailing conditions and potential risks without offering a definitive prediction of future market performance. It empowers the client to make an informed decision based on facts and their own risk tolerance. This aligns with Arizona Revised Statutes Title 32, Chapter 20, which governs real estate transactions and mandates that licensees act with honesty, integrity, and in the best interest of their clients, which includes providing accurate and relevant information about the market. Ethical practice dictates transparency and avoiding speculative statements. An incorrect approach would be to assure the client that the market will continue to appreciate at its current rate, encouraging them to proceed with a purchase based on this guarantee. This is a failure to adhere to the principle of providing accurate market information and could be construed as providing investment advice, which is outside the broker's purview and potentially violates Arizona's real estate licensing laws by making unsubstantiated claims. Another incorrect approach is to downplay the economic indicators and focus solely on the recent rapid appreciation, suggesting that the current trend is sustainable indefinitely. This misrepresents the market's volatility and fails to adequately inform the client of potential risks, violating the duty of care and honesty owed to the client under Arizona real estate regulations. Finally, advising the client to wait for a significant market downturn before purchasing, based on the broker's personal economic forecast, is also an inappropriate response. This constitutes speculative financial advice and oversteps the broker's professional boundaries, potentially leading to a missed opportunity for the client and violating the principle of acting solely on factual market data and the client's stated objectives. Professionals should employ a decision-making framework that prioritizes objective data analysis, clear communication of market conditions and associated risks, and a thorough understanding of their licensing scope. This involves presenting factual information, explaining its implications without making predictions, and guiding the client to make their own informed decisions based on their financial situation and risk appetite. Question 12. Operational review demonstrates that a married couple in Arizona is purchasing a property together and is discussing how to hold title. They have expressed a desire for the property to pass to the surviving spouse automatically upon the death of one of them, but also want to ensure that each spouse can independently sell or encumber their individual interest in the property during their lifetime. Which of the following explanations most accurately reflects the implications of these desires under Arizona law? Option A. Tenancy in common is the most suitable option, as it allows for independent sale or encumbrance of each owner's share and does not mandate automatic inheritance. Option B. A simple tenancy by the entirety is the best choice, as it automatically passes the property to the surviving spouse and prevents either spouse from selling their interest without the other's consent. Option C. Joint tenancy with right of survivorship is the most appropriate form of ownership, as it ensures automatic inheritance by the surviving spouse and allows each owner to convey their individual interest. Option D. Community property with right of survivorship is the only option that satisfies both desires, as it provides for automatic inheritance and allows for independent management of each spouse's interest. Correct answer is C. Joint tenancy with right of survivorship is the most appropriate form of ownership, as it ensures automatic inheritance by the surviving spouse and allows each owner to convey their individual interest. Explanation. Scenario analysis. This scenario presents a common challenge for real estate professionals in Arizona, advising clients on the implications of different property ownership structures. The challenge lies in accurately explaining the nuances of each ownership type, particularly the rights and responsibilities associated with joint tenancy versus tenancy in common, and ensuring the client's chosen method aligns with their intentions and Arizona law. Misunderstanding these distinctions can lead to unintended consequences regarding inheritance, liability, and the ability to sell or encumber the property. Correct approach analysis. The best professional approach involves clearly and accurately explaining the fundamental differences between joint tenancy and tenancy in common under Arizona law. This includes detailing how each form of ownership handles the right of survivorship, present in joint tenancy, absent in tenancy in common, and the ability to convey or inherit an interest independently. Specifically, emphasizing that joint tenancy automatically passes the deceased owner's interest to the surviving joint tenant, while tenancy in common allows for the interest to be willed to heirs or beneficiaries, is crucial. This approach ensures the client is fully informed and can make a decision that reflects their estate planning goals and legal understanding, adhering to Arizona revised statutes concerning property ownership. Incorrect approach is analysis. One incorrect approach would be to broadly state that both joint tenancy and tenancy in common allow for multiple owners without elaborating on the critical differences in inheritance and transferability. This is a failure to provide adequate disclosure and advice, potentially misleading the client about their rights and the future disposition of their property interest. Arizona law distinguishes these forms of ownership for specific legal reasons, and failing to highlight these distinctions is professionally negligent. Another incorrect approach would be to recommend joint tenancy solely because it simplifies the transfer of property upon death, without discussing the client's specific intentions for their heirs or beneficiaries. This overlooks the client's autonomy and potential desire to distribute their property according to a will, which is a fundamental right. It also fails to acknowledge that joint tenancy can have unintended tax implications or create complications if one joint tenant wishes to sell their interest independently. A third incorrect approach would be to suggest that the choice between joint tenancy and tenancy in common is purely a matter of personal preference with no significant legal ramifications. This is factually incorrect and demonstrates a lack of understanding of Arizona property law. The legal distinctions are significant and have profound effects on inheritance, creditor rights, and the ability to manage or dispose of the property interest. Professional reasoning. Professionals should always prioritize clear, accurate, and comprehensive client education. When advising on property ownership, the decision-making process should involve 1. Understanding the client's goals and intentions for the property, including their estate planning wishes. 2. Thoroughly explaining the legal characteristics and implications of each ownership type available under Arizona law, focusing on differences in survivorship, inheritance, and transferability. 3. Advising the client to consult with an attorney to ensure their chosen ownership structure aligns with their overall legal and financial plan. The professional's role is to inform, not to make the ultimate legal decision for the client. Question: Operational review demonstrates that a married couple in Arizona is purchasing a property together and is discussing how to hold title. They have expressed a desire for the property to pass to the surviving spouse automatically upon the death of one of them, but also want to ensure that each spouse can independently sell or encumber their individual interest in the property during their lifetime. Which of the following explanations most accurately reflects the implications of these desires under Arizona law? Options: A. Joint tenancy with right of survivorship is the most appropriate form of ownership, as it ensures automatic inheritance by the surviving spouse and allows each owner to convey their individual interest. B. Tenancy in common is the most suitable option, as it allows for independent sale or encumbrance of each owner's share and does not mandate automatic inheritance. C. Community property with right of survivorship is the only option that satisfies both desires, as it provides for automatic inheritance and allows for independent management of each spouse's interest. D. A simple tenancy by the entirety is the best choice, as it automatically passes the property to the surviving spouse and prevents either spouse from selling their interest without the other's consent. Question 13. Strategic planning requires an Arizona licensed real estate broker to develop a robust tenant screening process. When presented with multiple qualified applicants for a rental property in Phoenix, what is the most ethically sound and legally compliant method for selecting the best tenant? Option A. Prioritize applicants based on their occupation and perceived financial stability, as this often indicates a reliable tenant. Option B. Select the applicant who presents the most favorable attitude and demeanor during the initial viewing and application submission. Option C. Develop objective screening criteria based on financial qualifications, rental history, and background checks, and apply these criteria uniformly to all applicants, documenting each step of the process. Option D. Favor applicants who are referred by current tenants or who express a strong personal connection to the property or landlord. The correct answer is C. Develop objective screening criteria based on financial qualifications, rental history, and background checks, and apply these criteria uniformly to all applicants, documenting each step of the process. Explanation: This scenario presents a professional challenge for an Arizona licensed real estate broker because it requires balancing the landlord's desire to rent to a financially stable tenant with the legal and ethical obligations to avoid discriminatory practices during the tenant screening process. The broker must navigate potential biases and ensure that selection criteria are applied consistently and fairly to all applicants, adhering strictly to Arizona revised statutes and federal fair housing laws. The best approach involves establishing clear, objective, and non-discriminatory screening criteria in advance, applying them uniformly to all applicants, and documenting the process meticulously. This method ensures compliance with Arizona's fair housing laws, which prohibit discrimination based on race, color, religion, sex, familial status, national origin, and disability, as well as any other protected classes under federal law. By focusing on financial qualifications, rental history, and background checks that are relevant to tenancy and applied equally, The broker protects both the landlord's interests and the applicant's rights, minimizing legal risk and upholding ethical standards. An approach that involves considering the applicant's perceived financial stability based on their occupation, without a standardized financial assessment, is ethically flawed and legally risky. This can easily lead to unconscious bias and potential discrimination against individuals in certain professions or those with less conventional but equally stable income sources, violating fair housing principles. Another unacceptable approach is to prioritize applicants who are referred by current tenants or who express a strong personal connection to the property or landlord. Referrals can sometimes yield good tenants. Making them a primary selection factor can inadvertently favor applicants who are part of existing social networks, potentially excluding qualified applicants from diverse backgrounds and creating an appearance of favoritism, which is contrary to fair housing mandates. Furthermore, an approach that involves subjective assessments of an applicant's attitude or demeanor during the application process is highly problematic. Such subjective criteria are difficult to quantify, prone to bias, and can easily mask discriminatory intent, even if unintentional. Fair housing regulations require objective and verifiable criteria for tenant selection. Professionals should employ a decision-making framework that begins with understanding and internalizing all applicable fair housing laws in Arizona. This includes developing a written tenant screening policy with objective criteria that are consistently applied. During the screening process, all applicant information should be gathered and evaluated against these predefined criteria. Any deviations or special considerations should be carefully documented and justified based on objective factors, not subjective impressions or protected characteristics. Regular training on fair housing and ethical practices is crucial for all agents involved in property management. Question 14. The evaluation methodology shows a real estate licensee in Arizona is tasked with listing a property that includes a large manufacturing facility, a significant warehouse space, and a small administrative office area. The client has described it broadly as a business property. Considering the primary function and layout, which classification best aligns with Arizona's real estate framework for this property? Option A, residential property as it has an office area where people work. Option B, commercial property because it contains an administrative office space. Option C, agricultural property if the land surrounding the facility has potential for future development. Option D, industrial property due to its primary function as a manufacturing and warehousing hub. The correct answer is D, industrial property due to its primary function as a manufacturing and warehousing hub. Explanation. The evaluation methodology shows a scenario where a real estate licensee must accurately classify property types to ensure compliance with Arizona's licensing laws and ethical obligations. Misclassifying property can lead to significant legal and ethical repercussions, including disciplinary action from the Arizona Department of Real Estate, ADRE, potential lawsuits from clients, and damage to the licensee's professional reputation. The challenge lies in understanding the nuances of each property classification and applying them correctly to specific real-world situations, especially when properties may exhibit characteristics of multiple types. The best approach involves a thorough understanding of the primary use and characteristics of the property, aligning with the definitions provided by Arizona law and common real estate practice. This means identifying the dominant purpose for which the property is intended or currently used. For example, a property primarily designed for manufacturing and distribution, even if it has a small office component, will be classified as industrial. This meticulous classification ensures that all marketing, disclosures, and transaction processes adhere to the specific regulations and expectations associated with that property type in Arizona. An incorrect approach would be to classify the property based solely on the most visible or easily understood feature, ignoring its primary function. For instance, labeling a large warehouse with a small administrative office as commercial simply because it has an office space would be a misclassification. This fails to recognize the core industrial purpose of the facility and could lead to marketing it to an inappropriate audience or under regulations not suited for industrial properties. Another incorrect approach is to classify based on the potential for future use rather than its current or intended primary use. Vacant parcel of land that is zoned for commercial development but is currently used for agricultural purposes should be classified based on its current use or the most immediate intended use, not speculative future development. This can lead to misrepresentation and marketing errors. Finally, classifying a property based on the client's casual description without independent verification is also professionally unsound. While client input is valuable, the licensee has a duty to exercise due diligence and apply their professional knowledge to accurately classify the property according to Arizona's real estate framework. Relying solely on a client's potentially inaccurate or incomplete description can lead to significant errors and ethical breaches. Professionals should approach such situations by first consulting the Arizona revised statutes and ADREG guidelines for property definitions. They should then conduct a comprehensive site inspection, consider zoning regulations, and analyze the property's primary intended use. If ambiguity exists, seeking clarification from experienced colleagues, legal counsel, or the ADREG itself is a prudent step. The decision-making process should prioritize accuracy, transparency, and adherence to regulatory requirements. Question 15. Quality control measures reveal that an Arizona real estate licensee is preparing to list a single-family home for sale. The licensee is considering which valuation method to prioritize to advise the seller on an appropriate listing price. Which valuation method should the licensee primarily rely upon for this residential property, and why? Option A. Income approach, as it can estimate the property's potential rental income, which is a factor in its overall value. Option B. Cost approach, as it accounts for the cost of rebuilding the property and any depreciation. Option C. A combination of all three approaches equally without considering the property type or market conditions. Option D. Comparative market analysis, as it reflects current market demand and is specifically required by Arizona regulations for such services. The correct answer is D. Comparative market analysis, as it reflects current market demand and is specifically required by Arizona regulations for such services. Explanation. Scenario analysis. This scenario is professionally challenging because a real estate licensee in Arizona must provide an accurate and defensible valuation to their client, the seller. Failing to do so can lead to client dissatisfaction, potential legal action, and disciplinary action from the Arizona Department of Real Estate. The licensee must select the most appropriate valuation method based on the property type and available data, demonstrating a thorough understanding of the Arizona real estate regulations and ethical obligations. The pressure to present a high value to secure a listing must be balanced with the professional duty to provide an objective assessment. Correct approach analysis. The most appropriate approach in this scenario is the comparative market analysis. This method involves analyzing recent sales of similar properties in the immediate vicinity, adjusting for differences in features, condition, and location. This approach is best because it directly reflects what buyers are currently willing to pay for comparable properties in the specific Arizona market. Arizona Administrative Rule R-4-28-1101 G requires licensees to prepare a written market analysis or comparative market analysis when offering real estate brokerage services for the sale or lease of real property. This analysis must be based on current sales data and market trends, which is precisely what the comparative market analysis provides. It is ethically imperative to base valuations on objective, market-driven data to avoid misleading the client. Incorrect approaches analysis. Using only the income approach would be inappropriate because it is primarily designed for income-producing properties, such as apartment buildings or commercial spaces. While the property might have rental potential, its primary purpose as a single-family residence means that its value is more directly tied to what similar homes have sold for, not its potential rental income. Relying solely on this method ignores the fundamental principles of residential property valuation in Arizona and could lead to a significantly inaccurate valuation. Utilizing only the cost approach would also be an incorrect and potentially misleading strategy. This method estimates the cost to replace the property with a similar one, minus depreciation. While it can be useful for unique or newly constructed properties where comparable sales are scarce, it is generally less reliable for older, established homes. Depreciation is difficult to accurately estimate, and the cost approach does not directly reflect current market demand or what buyers are willing to pay, which is a critical factor in the Arizona real estate market. This approach fails to align with the market-driven principles expected by the Arizona Department of Real Estate. Professional reasoning. When faced with valuing a residential property in Arizona, A licensee should first consider the comparative market analysis as the primary tool. This aligns with regulatory requirements and ethical obligations to provide a market-based valuation. If the property has unique characteristics or is an income-producing asset, then the income approach or cost approach might be considered as supplementary methods or for specific property types, but never as the sole basis for a residential valuation, without strong justification and clear disclosure to the client. The licensee must always prioritize methods that reflect current market conditions and are supported by verifiable data, as mandated by Arizona law and ethical practice. Question 16. System analysis indicates that an Arizona licensed real estate broker is representing a seller in a listing agreement. During the marketing period, the broker's associate shows the property to a prospective buyer who expresses strong interest and indicates they do not have their own agent. The broker recognizes this buyer as a former client from a previous transaction. What is the most appropriate and legally compliant course of action for the broker to take immediately? Option A. Inform only the seller about the buyer's previous relationship with the broker and proceed with facilitating the transaction without explicitly informing the buyer about the dual agency. Option B. Inform only the prospective buyer about their previous relationship with the broker and proceed with representing them in their offer without disclosing this to the seller. Option C. Proceed with representing the buyer in their offer to purchase the property, assuming the buyer's prior relationship with the broker implies consent for dual agency. Option D. Immediately disclose the potential dual agency situation in writing to both the seller and the prospective buyer, clearly outlining the implications, and obtain their informed written consent before proceeding with any further representation of the buyer. The correct answer is D. Immediately disclose the potential dual agency situation in writing to both the seller and the prospective buyer, clearly outlining the implications, and obtain their informed written consent before proceeding with any further representation of the buyer. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate broker to navigate potential conflicts of interest and ensure compliance with Arizona's real estate laws, specifically concerning disclosure and fiduciary duties. The broker must act in the best interest of their client, while also being aware of the legal implications of representing parties with opposing interests. Careful judgment is required to maintain ethical standards and avoid legal repercussions. Correct approach analysis. The best professional practice involves the broker immediately disclosing the potential dual agency situation to both parties. This disclosure must be in writing and clearly explain the implications of the broker representing both the buyer and the seller. The broker should then obtain informed consent from both parties before proceeding. This approach is correct because Arizona Revised Statutes, A.R.S. Section 32-2151, 02 mandates disclosure of agency relationships and prohibits dual agency without the written consent of all parties. Ethically, this transparency upholds the fiduciary duty owed to clients by ensuring they are fully aware of the broker's role and potential conflicts. Incorrect approach is analysis. One incorrect approach is to proceed with the transaction without informing either party about the dual agency. This is a direct violation of A.R.S. Section 32-2151, 02, which requires disclosure of agency relationships. Ethically, this failure constitutes a breach of fiduciary duty, as it deprives the parties of the right to make informed decisions about who is representing their interests. Another incorrect approach is to inform only one party of the dual agency while keeping it from the other. This is also a violation of A.R.S. Section 32-2151, 02 and is ethically unsound. It creates an unfair advantage for the informed party and a disadvantage for the uninformed party, undermining the principle of fair dealing and full disclosure required of real estate professionals in Arizona. A third incorrect approach is to assume that since the buyer is a repeat client, consent for dual agency is implied. Arizona law requires explicit written consent for dual agency, not implied consent. Proceeding without this explicit consent, even with a repeat client, is a regulatory failure and an ethical lapse, as it bypasses the necessary legal safeguards and informed decision-making process for all parties involved. Professional reasoning. Professionals should adopt a proactive and transparent approach to agency disclosures. When a potential conflict of interest arises, such as the possibility of dual agency, the immediate step should be to review the relevant Arizona statutes and ethical guidelines. The decision-making process should prioritize full and timely disclosure to all parties involved, followed by obtaining written, informed consent. If consent cannot be obtained from all parties, the broker must decline to represent both sides and advise the parties to seek separate representation. This systematic approach ensures legal compliance and upholds the highest ethical standards in real estate practice. Question 17. The performance metrics show a significant increase in prevailing interest rates since a buyer in Arizona initially secured their pre-approval for a mortgage. The buyer expresses concern that this rate hike will prevent them from affording the property they wish to purchase. What is the most appropriate course of action for the Arizona real estate licensee representing this buyer? Option A. Recommend a specific mortgage lender that the licensee has a good working relationship with, assuring the buyer that this lender can likely accommodate the new rate environment. Option B. Advise the buyer to pause the transaction until interest rates potentially decrease, without suggesting any immediate steps to explore current financing possibilities. Option C. Educate the buyer on how rising interest rates impact loan affordability and monthly payments, and strongly advise them to consult with a mortgage broker to reassess their loan qualification and explore available financing options. Option D. Reassure the buyer that financing will likely still be obtainable at the previously discussed terms and encourage them to proceed with the purchase agreement as planned. The correct answer is C. Educate the buyer on how rising interest rates impact loan affordability and monthly payments, and strongly advise them to consult with a mortgage broker to reassess their loan qualification and explore available financing options. Explanation. The performance metrics show a significant increase in interest rates, impacting the affordability of a property for a potential buyer. This scenario is professionally challenging because it requires the real estate licensee to navigate the delicate balance between advocating for their client's best interests and adhering to Arizona's stringent disclosure and ethical obligations regarding financing. Missteps can lead to legal repercussions, disciplinary action from the Arizona Department of Real Estate, and damage to professional reputation. The best approach involves proactively educating the buyer about the current interest rate environment and its implications for their loan qualification and monthly payments, while also advising them to consult with a qualified mortgage professional. This is correct because Arizona law, specifically through the Arizona Department of Real Estate's rules and ethical guidelines for licensees, mandates that agents provide honest and competent service. This includes advising clients on matters within their expertise and referring them to other professionals when necessary. By facilitating a discussion about interest rate impacts and encouraging consultation with a mortgage broker, the licensee fulfills their duty of care and ensures the buyer makes informed decisions based on current market realities and professional financial advice. An incorrect approach would be to downplay the impact of rising interest rates and assure the buyer that financing will be secured at the previously discussed terms. This is ethically problematic as it constitutes a misrepresentation of the current market conditions and potentially leads the buyer to believe they can secure financing that is no longer feasible. It violates the duty of honesty and good faith. Another incorrect approach would be to recommend a specific lender or loan product without disclosing any potential referral fees or conflicts of interest, or without ensuring the lender is reputable and suitable for the buyer's needs. This could violate Arizona's disclosure requirements regarding referral fees and potentially lead to the buyer receiving unsuitable financing, breaching the duty of competence and loyalty. A further incorrect approach would be to cease communication with the buyer once the interest rate increase is noted, leaving them to figure out the financing challenges on their own. This demonstrates a failure to provide continued support and guidance, violating the licensee's duty to act in the client's best interest throughout the transaction. Professionals should approach such situations by first understanding the client's financial situation and goals. They should then leverage their knowledge of the real estate market and financing trends to explain potential impacts. Crucially, they must adhere to their disclosure obligations and ethical duties by recommending consultation with qualified financial professionals, such as mortgage brokers, to obtain accurate and personalized financing advice. This ensures the client is empowered with accurate information to make sound decisions. Question 18. Analysis of a client's financial situation in Arizona reveals they have a moderate income, a desire for the lowest possible initial monthly payments to manage their budget, and express some concern about long-term financial predictability. As an Arizona-licensed real estate broker, which of the following approaches best fulfills your fiduciary duty and regulatory obligations when discussing mortgage options? Option A. Thoroughly explain the core differences between fixed rate, adjustable rate, and interest-only mortgages, detailing how each impacts payment stability, long-term costs, and risk, and then guide the client to consider their financial goals and risk tolerance to make an informed choice. Option B. Suggest an interest-only mortgage to maximize their immediate purchasing power and keep initial payments low, without detailing the principal repayment structure or the eventual balloon payment. Option C. Focus solely on the advertised low introductory rates of adjustable-rate mortgages, downplaying the potential for future rate increases and their impact on monthly payments. Option D. Recommend an adjustable-rate mortgage, emphasizing its lower initial interest rate and monthly payments, and briefly mention that rates may change in the future. The correct answer is A. Thoroughly explain the core differences between fixed rate, adjustable rate, and interest-only mortgages, detailing how each impacts payment stability, long-term costs, and risk, and then guide the client to consider their financial goals and risk tolerance to make an informed choice. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in Arizona to balance the fiduciary duty owed to a client with the need to present accurate and relevant information about mortgage options. The client's limited understanding of financial products, coupled with their stated desire for lower initial payments, creates a situation where a broker could inadvertently steer them towards a product that might not be in their long-term best interest, potentially leading to future financial distress and regulatory scrutiny. The broker must act with integrity and competence, ensuring the client makes an informed decision based on a clear understanding of the risks and benefits of each mortgage type. Correct approach analysis. The best professional practice involves thoroughly explaining the fundamental differences between fixed rate, adjustable rate, and interest-only mortgages, focusing on how each impacts monthly payments, long-term costs, and risk exposure. For a fixed-rate mortgage, the explanation should highlight the stability of principal and interest payments over the life of the loan, providing predictability. For an adjustable-rate mortgage arm, the explanation must clearly articulate that initial interest rates are typically lower but are subject to change based on market fluctuations, leading to potentially higher payments in the future. The risks associated with ARM rate increases, including payment shock, must be emphasized. For an interest-only mortgage, the broker must stress that initial payments cover only the interest, meaning the principal balance does not decrease, and the borrower will still owe the full loan amount at the end of the interest-only period, requiring a substantial balloon payment or refinancing. The broker should then guide the client to consider their financial goals, risk tolerance, and expected duration of homeownership to determine which product aligns best with their circumstances, without recommending a specific product, but rather facilitating an informed choice. This approach aligns with the Arizona Department of Real Estate's emphasis on consumer protection and the broker's duty to act in the client's best interest by providing comprehensive, unbiased information. Incorrect approach is analysis. Recommending an adjustable-rate mortgage solely because it offers lower initial payments, without a detailed explanation of the risks associated with future rate increases and potential payment shock, is ethically problematic and potentially violates Arizona's consumer protection laws. This approach prioritizes a short-term benefit over the client's long-term financial security and fails to meet the standard of providing adequate disclosure. Suggesting an interest-only mortgage as a way to maximize purchasing power or achieve lower initial payments, without clearly explaining that the principal balance will not be reduced and that a large balloon payment or refinancing will be required at the end of the interest-only period, is a severe ethical and regulatory failure. This misrepresents the nature of the loan and could lead to significant financial hardship for the client. Focusing only on the advertised low initial interest rate of an adjustable-rate mortgage and downplaying the possibility of future rate increases, or failing to explain the index and margin that determine rate adjustments, is misleading. This selective disclosure prevents the client from making a truly informed decision and breaches the broker's duty of full disclosure. Professional reasoning. Professionals should adopt a client-centric approach, prioritizing education and informed consent. When discussing complex financial products like mortgages, the process should involve 1. Active listening to understand the client's financial situation, goals, and concerns. 2. Providing clear, concise, and comprehensive explanations of all available options, including their advantages, disadvantages, and associated risks, using plain language. 3. Avoiding any form of recommendation that could be construed as steering the client towards a product that might not be suitable for their long-term interests. 4. Encouraging the client to consult with independent financial advisors or mortgage lenders for further clarification. 5. Documenting all discussions and disclosures made to the client. This systematic approach ensures compliance with regulatory requirements and upholds the highest ethical standards. Question 19. The review process indicates that an Arizona loan officer, who is friends with a potential borrower, has submitted a loan application with incomplete income verification and a property appraisal that appears to be at the high end of its estimated value. The loan officer is aware of these issues, but is under pressure to meet their quarterly closing quota. What is the most appropriate course of action for the loan officer in this situation? Adhering to Arizona's regulatory framework for loan underwriting and approval. Option A. Forward the application with a note to the underwriting department highlighting the incomplete documentation and the potentially inflated appraisal, leaving the final decision entirely to them. Option B. Thoroughly investigate the income discrepancies and obtain all necessary supporting documentation, and request a more conservative appraisal or a second opinion if the current appraisal seems questionable, regardless of personal relationships or closing quotas. Option C. Approve the loan based on the borrower's verbal assurances of future income and the existing appraisal, prioritizing the closing quota and the personal friendship. Option D. Overlook the income verification issues and accept the current appraisal, assuming the borrower will be able to manage the payments, to ensure the loan is closed before the quarter ends. The correct answer is B. Thoroughly investigate the income discrepancies and obtain all necessary supporting documentation, and request a more conservative appraisal or a second opinion if the current appraisal seems questionable, regardless of personal relationships or closing quotas. Explanation. The review process indicates a potential conflict of interest and a violation of underwriting principles in Arizona. This scenario is professionally challenging because it requires the loan officer to balance the desire to close a deal with the fiduciary duty to the lender and the borrower, ensuring the loan is sound and compliant with Arizona revised statutes, ARS, and established underwriting standards. The pressure to meet quotas can sometimes cloud judgment, making adherence to regulations paramount. The correct approach involves a thorough and objective evaluation of the borrower's financial capacity and the property's value, independent of any personal relationship or external pressure. This means meticulously reviewing all submitted documentation, verifying income and employment, assessing creditworthiness, and ensuring the loan-to-value ratio is within acceptable limits, all in accordance with Arizona's lending regulations and the lender's policies. This approach upholds the integrity of the underwriting process, protects the lender from undue risk, and ensures the borrower is not taking on a loan they cannot reasonably repay, aligning with the principles of responsible lending mandated by Arizona law. An incorrect approach would be to overlook discrepancies in the borrower's income documentation due to the personal relationship. This bypasses the critical verification step required by sound underwriting practices and potentially violates ARS Section 6-808, which mandates that lenders act in good faith and with due diligence. Another incorrect approach would be to approve the loan based on a verbal assurance from the borrower about future income without any supporting documentation. This is a direct contravention of standard underwriting protocols and Arizona's regulatory expectations for verifiable financial information, exposing the lender to significant risk. Finally, approving the loan solely to meet a quarterly quota, despite identified risks and incomplete documentation, demonstrates a severe lapse in professional judgment and a disregard for regulatory compliance and ethical lending practices in Arizona. Professionals should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct above all else. This involves a systematic review of all loan applications, objective assessment of risk factors, strict adherence to established underwriting guidelines, and a commitment to verifying all submitted information. When faced with pressure or potential conflicts, professionals must refer to the relevant Arizona statutes and internal policies, and if necessary, seek guidance from supervisors or compliance departments to ensure decisions are sound, legal, and ethical. Question 20. Performance analysis shows that a real estate brokerage in Arizona has a trust account with a current balance of $15,000. During the past month, the brokerage paid $2,500 in rent and utilities directly from this trust account, intending to transfer earned commissions to cover these expenses later. The brokerage also received a $5,000 earnest money deposit for a new transaction, which is currently in the trust account. The brokerage operating account has a balance of $1,000. If the brokerage earned commission for the month, based on closed transactions, is $4,000, what is the correct financial management approach to ensure compliance with Arizona law and ADRE regulations? Option A. Transfer the $4,000 earned commission from the operating account to the trust account, and then use $2,500 of the trust account balance to pay the rent and utilities directly from the trust account. Option B. Immediately transfer the $4,000 earned commission from the operating account to the trust account to cover the rent and utilities paid, and then formally withdraw the $2,500 for rent and utilities from the trust account into the operating account. Option C. Immediately withdraw the $4,000 earned commission from the trust account and deposit it into the operating account. Then use the $1,000 in the operating account to pay the rent and utilities, and inform the client that their earnest money is being held securely. Option D. Transfer the $4,000 earned commission from the operating account to the trust account, and then use $2,500 of the trust account balance to reimburse the operating account for the rent and utilities paid. The correct answer is B. Immediately transfer the $4,000 earned commission from the operating account to the trust account to cover the rent and utilities paid, and then formally withdraw the $2,500 for rent and utilities from the trust account into the operating account. Explanation. Scenario analysis. This scenario presents a common challenge for real estate brokers in Arizona, accurately reconciling trust account funds with their operating expenses. The difficulty lies in ensuring that client funds are never commingled with personal or business funds, and that all financial transactions are meticulously documented and reported according to Arizona Revised Statutes, Rs. Title 32, Chapter 15, and the rules promulgated by the Arizona Department of Real Estate, ADRE. Failure to maintain proper financial records and adhere to trust account regulations can lead to severe disciplinary actions, including license suspension or revocation, and significant financial penalties. Correct approach analysis. The best professional practice involves meticulously tracking all trust account deposits and disbursements, ensuring that no operating expenses are paid directly from the trust account. Any earned commissions or fees should be formally withdrawn from the trust account and deposited into the broker's operating account. This approach directly aligns with ARS Section 32-2151, which mandates that all funds entrusted to a licensee be deposited in a neutral escrow depository or the broker's trust account, and R Section 32-2051-01A, which prohibits the use of trust funds for personal use or to pay operating expenses. By adhering to this, the broker maintains the integrity of client funds and complies with ADRE record-keeping requirements, which necessitate clear segregation of trust and operating funds. Incorrect approaches analysis. Paying operating expenses directly from the trust account, even if intending to reimburse later, is a direct violation of ARS Section 32-2151-01A. This action commingles client funds with business funds, creating a significant risk of misappropriation and making it difficult to accurately track the balance of client funds. It also violates ADRE's stringent record-keeping rules, which require a clear audit trail for all trust account transactions. Using a portion of a client's earnest money deposit to cover the broker's own operational costs, even with the client's verbal consent, is also a serious violation. Trust funds are held in a fiduciary capacity and cannot be used for any purpose other than that for which they were entrusted, unless specifically authorized by the terms of the escrow agreement and disbursed according to those terms. Verbal consent is insufficient to authorize the use of trust funds for operating expenses, and R Section 32-2151 A and B require written agreements for escrow and disbursement. Treating the trust account as a general business account for short-term cash flow management, even with the intention of replenishing it before the next audit, is a critical error. This practice fundamentally undermines the purpose of a trust account, which is to safeguard client funds. It creates a high risk of insufficient funds when a disbursement is required for the client, leading to potential legal liabilities and disciplinary action from the address. Professional reasoning. Professionals in Arizona must adopt a proactive and meticulous approach to financial management. This involves establishing clear internal controls for trust account management, including regular reconciliations and strict adherence to disbursement procedures. When faced with financial pressures, a broker should always prioritize the integrity of client funds over immediate business needs. If cash flow is a concern, seeking alternative business financing or adjusting operational expenses are the appropriate professional responses, rather than compromising trust account regulations. A thorough understanding of ARS Title 32, Chapter 15, and ADRE rules is paramount for maintaining a compliant and ethical real estate brokerage.